John, I saw an article popped up on my phone about the Nashville DA's office from yesterday in Tennessee. I guess they finally came out with the fact that they can audio tape like various areas of their office, and they can implement attorneys there, even sometimes they get a client, and they can videotape and then directly to whatever prosecutors and the Attorney General's office, like confirming these details, would say, well,
all right, guys, mics are on now.
it's not a crime. They're not criminal. I guess they're over. Now, the person that has already was like, oh, it's law enforcement office, so these are just video. They say that the article said that we have to post in various places. But still, that's ridiculous. But I'm going to have to
Boris, hey, how are you? I'm giving you a mic check. Testing 1, 2, 3, 4, 5, 6. Oh, sorry. Sorry. Testing 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Be on 20-second delay. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Oh, okay, cool. Oh, perfect. Great. So you got me. Testing. Okay. All right. Thank you, Boris. Thank you so much. Yep. There's in Minnesota. 5, 6, 2, 3, 4, 5, 6, 7, 8, 9, 10. You're on 27. Oh, okay. That's fine. That's fine. It's like a lifetime, man. Testing 1, 2, 3, 4, 5. Testing 1, 2. Okay, thanks, man. See ya. Bye.
Catherine.
She got one. Catherine has
So
one.
we got one. And her, his partner, right? And for you.
You didn't get that on the record.
So everybody got one, right?
Everybody good?
All rise. Hear ye, hear ye, hear ye. This Honorable Division of Criminal Court 10. The 30th Judicial District of the State of Tennessee is now open for the transaction of business pursuant to adjournment. All persons having business with this court draw near, give attention, and ye shall be heard. The Honorable Judge Jennifer Johnson Mitchell presiding. You may be seated.
Good morning. Any business we need to take care of before we bring the jury in?
No, Your Honor.
So Evans, you'll be up first.
Yes, Your Honor.
You can bring in the jury. Ladies and gentlemen, before the jury comes in, I will start to read this jury charge very soon. There will be no movement during the charge. The door will be locked. Nobody will enter and nobody will exit. It's gonna take me about 15, 20 minutes to read this charge. So if you don't feel like you're gonna be able to sit still during this time frame, please exit now.
Jury now enter into the courtroom, Your Honor.
Good morning. Good morning. I trust again that everybody has good night. Mr. Evans, can you call your first witness?
Your Honor, the defense rests.
Ladies and gentlemen, you have heard the truth in this matter. What you have had in your seats, is a jury charge. This is my portion of this trial. It's the law. Now, the law states that I have to read it to you. Please don't think I am insulting your intelligence by reading to you. I know you can read for yourself, but the law states that I have to read it and you all have to read it at the same time. Okay. That is your copy, feel free to write on it. I have the official copy here that will go back with you to the jury room. I cannot write on this copy, but feel free to make any notes that you'd like to make, and any changes that I have to make that I see that need to be made will be made on the official copy. State of Tennessee versus Justin Johnson. Members of the jury. The evidence in this case has been completed, and it is now my duty to instruct you as to the law. After I instruct you as to the law, the state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Duties of the court and the jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court, render their verdicts with absolute impartiality. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality as you think justice and truth dictate. The indictment in this case is the formal written accusation charging the defendant with the crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made, do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, the opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on the statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of this court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element necessary to constitute the offense. Crimes charged and pleaded. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within the offense are the lesser included offenses: facilitation to wit, conspiracy to commit first-degree murder. The second count of the indictment charges the offense of first-degree murder. Embraced and included within the offense are the lesser included offenses of second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. The third count of the indictment charges the offense convicted felon in possession of a firearm. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of this conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those with whom the person conspires. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. However, mere presence is not sufficient to support a conviction. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the conspiracy, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on page 4. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable in count 2 in this indictment. First-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Facilitation to wit, first-degree murder. Any person who commits the offense of facilitation to wit, first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder has been defined on page 8. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit second-degree murder. Any person who commits the offense of facilitation to wit second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific offense of second-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder has been defined on page 9. Knowingly means that the person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally or knowingly, and that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit voluntary manslaughter. Any person who commits the offense of facilitation to wit voluntary manslaughter is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the voluntary manslaughter, and that the defendant furnished each such assistance knowingly. Voluntary manslaughter has been defined on page 13. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any person who, facilitation to wit aggravated assault. Any person who commits the offense of facilitation to wit aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the aggravated assault, and that the defendant furnished such assistance knowingly. Aggravated assault has been defined on page 14. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Simple assault. Any person who commits a simple assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to another, and that the defendant acted either intentionally, knowingly, or recklessly. Facilitation to wit simple assault. Any person who commits the offense of facilitation to wit simple assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of simple assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the simple assault, and that the defendant furnished such assistance knowingly. Simple assault has been defined on page 18. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 3 in this indictment: convicted felon in possession of a firearm. Any person having been convicted of one of certain specific felonies who possesses a firearm is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant had been convicted of a specified felony, and that the defendant, after such felony conviction, possessed a firearm, and that the defendant acted either intentionally, knowingly, or recklessly. Firearm means any weapon that will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find from the proof that the defendant has been convicted of another crime or crimes than that for which he is presently on trial, you may not consider such evidence as proof of his disposition to commit the crime for which he is on trial. The defendant has pled not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all the evidence presented in this case by the state and by the defendant and give it full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. Whether the witness had a motive to testify truthfully or to testify untruthfully. And any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Intent means that the person acts intentionally with respect to the nature of the conduct or to the results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Absent material witness. When it is within the power of the state or the defendant to produce a witness who possesses peculiar knowledge concerning facts essential to that party's contention and who is available to one side at the exclusion of the other, and the party to whom the witness is available fails to call such witness, an inference arises that the testimony of such witness would have been unfavorable to the side that should have called or produced such witness. Whether there was such a witness and whether such an inference has arisen is for you to decide, and if so, you are to determine what weight it shall be given. This inference does not apply to the defendant because he has a lawful right not to testify, and his failure to testify cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulation. A stipulation is an agreement between the parties. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. The parties have entered into two stipulations. The parties have stipulated that Adolph Thornton Jr. was a living person who is now deceased, and an autopsy was performed to substantiate these facts. The parties have also stipulated to the fact that the defendant, Justin Johnson, is a convicted felon, previously convicted on May 2nd of 2017 in Division 8 of the Criminal Court of Shelby County. Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community or leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight. If flight is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Multiple counts, finding of each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Notes. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. That is the law Ladies and gentlemen, we will now proceed with closing arguments.
Good morning.
Good morning.
So it's almost over, and I'm sure you all are happy. My name is Iris Williams. I'm one of the prosecutors on this case. And earlier this week, you heard opening statements. You heard opening statements from prosecution and from the defense attorney. And you were told all the things that you could expect this week. And one of those important things that you could expect was that it is not 1981 anymore, and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions. And it's even harder to hide who you know. But ladies and gentlemen, despite all of those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts: conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week we heard testimony from co-defendant Cornelius Smith. He testified for us, and he told us that he met Justin Johnson through Hernandez Govan, and that he knew Justin was a rapper, and he was also known by the name of Straight Drop. So Smith had known the defendant for a couple of months, and they hung out a couple of times before the murder. He was able to identify defendant in open court. And during his testimony, Smith told us that on November 17th, 2021, he and the defendant knew that Big Jook had a $100,000 hit on Dolph's head. Cornelius said that he and Justin agreed to kill Dolph together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting, facilitating, and, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is 1, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. Second, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake, there was no accident. Third, you have to prove that the killing was premeditated. And as we saw, or as we learned in voir dire last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car, you held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next, so we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children, She's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who is now deceased. Later on, we heard from Dr. Scantlebury. She was the medical examiner and performed the autopsy. She found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs. She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hawkins. He testified that he was head of Dolph Security for years. He was able to identify Dolph's car in the beginning of the Makitas video, and he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional? Back to Cornelius Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about the killing. He said that on the day of the murder, the defendant picked him up from his father's house. They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Jook had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, Cornelius Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car. Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the Makitas parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at Makitas. Cornelius Smith was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, Cornelius Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Jook. In that FaceTime call between Big Jook and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrived at Gospel Gardens, they received wound care. They change their clothes, and then they go their separate ways. After they go their separate ways, Cornelius Smith tells us that he went to retrieve his phone, and he went to go wipe down the car, the white Mercedes that was parked at Bradley. So with Cornelius Smith's testimony, we have established that the killing was unlawful. There was no evidence to show that this defendant was in fear, was protecting himself, or was protecting someone else. We also established that it was intentional. It's not an accident. You didn't mistakenly follow someone's car into Makita's parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit. So if that wasn't enough for you, we heard from some other people. We heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early hours of November 17th, 2021. Next, let me go back to Kirsten Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or a few hours after the cars were switched. Similarly, Jamarcus Johnson didn't know anything either. He just knew that he needed a ride. And his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone, he fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney. He was able to tell us about the 4 different bullet casings that were present at the murder scene. .40 caliber, attributable to a handgun. .762, attributable to an assault rifle that Cornelius Smith had. .223, attributable to a semi-automatic that Marcus Thornton probably would have had. And a 9mm casings found inside the store, which could be attributable to the handgun that Marcus Thornton had inside the store. That first one, though, the .40 caliber attributable to a handgun, was in the hand of the suspect with the Bass Pro hat. So, Sergeant Dabney also recovered the surveillance footage from Makita's and Gospel Gardens, showing this suspect in the same clothing that the defendant was in as he was leaving his apartment at 10:49 a.m. that morning. The timestamps on Gospel Garden and Makita's coincide with the times defendant's phone accessed those towers. We heard from Special Agent Garner, who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time that Kirsten Gardner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And it accessed those towers during the times of the murder, 12:22 p.m. to 12:23 p.m. on November 17th. Officer Garner also explained that the defendant's phone accessed the tower in the area of the 2-lane road in Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Sergeant Dabney identified the defendant being present for. So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m. on November 17, 2021. Not only did he place an outgoing call to Big Jook, he also received a text from Kiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device, sends the outgoing text to Jermaine Sears that he needs him. And you'll see in the surveillance footage of Haven Court on that day, at that time, a car that is associated with Jermaine Sears arrived shortly after the defendant arrives in a white Ford Expedition. So the next thing, convicted felon in possession of of a firearm. The three things that we have to prove beyond a reasonable doubt is that one, this defendant was a convicted felon or convicted of a specified felony. And two, after being convicted of a felony, this defendant possessed a firearm. And three, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, one, there was a stipulation or an agreement. The parties have stipulated that defendant Justin Johnson was convicted of a felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Cornelia Smith, who verified that the person in that Bass Pro hat was Justin Johnson, and that person held a gun. So based on all of that, we can see that we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to sleep well at night. Will you be able to rest easy knowing the decision that you made? My instinct says yes. And once you've had time to deliberate, I think yours will too. So that brings us to the end. The state has met its burden of proof beyond a reasonable doubt. You have all the evidence, all of the testimony, all of the stipulations, all of the videos, all the photographs. And now it's time for you to consider that evidence and apply your common sense. And after you do that, I think, well, actually, I expect that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms. Williams. Sir.
Thank you, Judge.
It's good to see y'all again. This is the last time you're going to have to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court and Mr. Hagerman, Ms. Iris, all of us agree you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening, right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible. And the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case. But it's heavy. And on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper. Wanted to make it as a rap artist. When you're going back through these exhibits, you're going to see a picture of him in front of the house on Bradley. You know, engaged in a music video, right, for his rap. kick to the side, kind of grin on his face, because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make beyond a reasonable doubt is the heaviest one, maybe one of the heaviest decisions you'll ever make. And you've had an opportunity to sit through the trial and hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have. I'm sure you have. And not to talk about the case. You know, the thing that you've been listening to for days, with people all around you that have going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully, to listen to one another, to review the evidence that you've heard, to talk about it, and render a decision. But to the degree you're working together, what you never have to do is abandon your conscience. Now, I don't mean conscience like Cornelia Smith, that conscience, right? Because I don't think he really meant that when you heard from him. He said, oh, the reason I decided to tell the truth is I got a conscience. And we all know that's not the type of thing you're dealing with. You take that more seriously. You mean it. He did. You've heard a lot of concepts, you know, the terms of art and the law, the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains that way. He didn't kill Adolph Ford Jr. He didn't conspire to kill Adolph Ford Jr. And he wasn't the man holding the pistol in the Makita video. And it's going to be up to you to decide that. To watch those videos. Watch them closely. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar. It doesn't mean the same. Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro ads. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it, other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson and said that person always wore a Bass Pro hat. You have to consider that. And then you have Sergeant Dabney, who, for the first time, I think he acknowledged this, sitting on the stand, says, I think those underwear are the same. They're both blue. You look at the underwear from two-lane apartments. You look back at the Makita video, those are the same underwear. Look at it. Look at the steel shots. And for yourself, determine, can you tell if those are the same? And as jurors, you get to make that call. You get to look at it for yourself and compare those. We've heard a lot about it's not 1981 anymore. And I agree, right? You know, we've got cameras, but like I told you in opening, what also has advanced tremendously since 1981 is the world of forensics, right? Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car? There's DNA in that car. You heard a lot about they wiped it. Cornelius Smith said he wiped it. And we'll get to whether you believe that or not in a minute, okay? But he says he wiped it. But he didn't. There's fingerprints on it. Kristen Garner's, Trayon Ingram's, and Cornelius Smith. There was DNA found. One of it coming back to Trayon Ingram, right? Not Justin Johnson. Now, there's a lot of talk about gloves, right? They made a big point to say, you see gloves in the video. Now, they want you to believe that Mr. Johnson's running around in his Mercedes, and the reason that his prints aren't on it are because he's wearing gloves. And mind you, Cornelius Smith, when he said he wiped the car, never said he wiped the driver's side of the car. Okay? If you believe that. And they want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos. You think, he's not wearing gloves. And he's got a little girl in tow that would presumably be in that car with him. No DNA recovered. None. Now, during proof, it was interesting because they would show the Mercedes go into crosstown and the Mercedes leave crosstown. And they would show a video of Mr. Johnson getting out and walking in the building or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes. And you heard they had a reel, right? The video was a reel when they're doing crosstown. And when I asked it, I think it was Detective or Sergeant Dabney about there was surely other cars going in and out at this very time. And he said, yeah. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Garner. Kristen Garner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen, that Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told me. And if you recall, Mr. Hagerman had to kind of go back at him. I think he said something like, I can't tell you that. And then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly, he starts evolving through the story. Still lying to law enforcement. He even looks at a video of himself, right, pumping gas and goes, "That's not me in the video." And he's like, "Okay, it's me." But they're trying to tell you Justin Johnson's at the Valero gas station, right? When he's pumping gas. Where is he? Now they want you to believe that this shadowy figure up in the right, top corner was Justin Johnson. And that he was the other passenger in the Infinity, but you can't really make out who he is. You have to rely on Kristen Garner. That's what you have to rely on. And we talked a little bit about, proof beyond a reasonable doubt. I said one of the ways that you could use to kind of understand it is proof so convincing that you would not hesitate to rely upon it in making the most important decisions of your life. And it's really simple, right? You look there and you go, would I trust Kristen Gardner with anything? If he told me something, would I believe it? The answer is no. Because the more he talked, right, the more you realize he and Trayon are in the Mercedes. They're driving around with a Draco rifle, assault rifle. The same one described as being held by Cornelius Smith in the shooting of Adolph Ford Jr. Their prints are in the car. He says they have, he said, a ton of guns in that car. And then he starts talking about how he's related to Dolph, and they were trying to dump the car before, right? And he's reaching out to Dolph's people to try to get rid of a car, which is the reason why after this happened, immediately, day after, he's calling Trayon going, my name's in this. My name's in this. Why would his name be? And B, why couldn't he just say, I don't have anything to do with this? And at Valero, you do see Trayon and Kristen. They're there front and center. Now, there's been a lot of talk about the phone and location. And in the state's argument just now, you heard her saying what the expert said, a phone using, a tower that could be and he said could be. He said was in the service area of the Valero gas station. Or then he said, I didn't do any drive tests, so I can't say what the coverage area would have been, right? And when you're looking at his slides, you've got that really thick PowerPoint exhibit. You'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small. They're really zoomed in on the map. And he's talking about, like, this, do you think this is thorough? This is thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, but then you have to ask yourself, well, what happens if you expand the map? And then you realize, and this is the exhibit I entered, you realize he's not even counting all the data and calls, because when you show what he left out at 12:23, right, at the time, immediately after Adolph Thornton Jr. was shot, there are several towers that Mr. Johnson's phone gets off of that are, one's 3 miles away in one direction. The other one is 3.2 miles away down by the Memphis airport. And then he has to go, I left those out. Not a really good explanation for why, right? Important. When there are a group of fine people that are looking to find the truth and have to make this decision. and need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be anywhere in a 3-mile radius, either any direction. And then you have to go, what is it? What does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time? Because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know. The next available tower is what a cell phone normally would look for, but also I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened. And he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm. Now, a little bit about conspiracy and some more of the facts as you heard them from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is this. There was no evidence at all that Justin Johnson was present for any meetings discussing this hit. What Cornelius Smith said was he met with Hernandez Govan and Jook, and Justin Johnson was not there. And then he said he met with Hernandez Govan and others on another occasion to discuss it, and Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement? He wasn't there. Now, you get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like we talked about in voir dire. Some of you, most of you, probably all of you have had to talk to somebody before and go, are they telling me the truth or not? And that's exactly what's here. But accomplice testimony is flagged because that person may have an interest in the outcome of this case. And you go, what is that interest? Well, Cornelius Smith, number one, told him. He had to admit, he didn't want to admit it, but he's meeting with the state. He's hoping to get a benefit on his own sentence. He's supposed to be telling the truth. But he's writing his sisters at the exact same time that he's meeting with the government, or the state rather, and telling them, I didn't do this, I'm just lying to get the deal. I'm just lying to get the deal. Now, is that his conscience, like he wanted to say? No. That's him telling his family. Why would he lie to his sisters? If he had a conscience, right? If he had done this out of the sense of, I did this awful thing, I feel awful, I've got to accept responsibility and tell the truth. No. But you remember, and it was kind of an interesting moment when he was testifying, because at one point he says, oh, that's not lying, I was gaming. Gaming's not lying. And the unfortunate part of all this is he's gaming everybody, including trying to game y'all. That's the problem. And he thinks he's going to walk. I mean, and the only person in this case who got paid for this. Remember, there is no proof whatsoever that Justin Johnson got a penny. Cornelius Smith got 50 grand for a lawyer for killing Adolph Thornton and didn't have to give it back. He didn't have to give it back. His lawyer was in the courtroom. And I asked him, I said, you remember, I said, how could you? You didn't give it back. You grew a conscience. What's going on with you? And he went, well, I did it. Service is rendered, right? And the lawyer, he's talking about with his sisters, he's saying, oh, well, my lawyer's telling me to cooperate. I'm walking. I'm not doing it unless I can walk. Now, he was asked by Mr. Hagerman, have I ever told you you're not going to have to go to prison? And he said, no, you haven't. But you have to keep in mind two things, right? At the time he was giving all this information that made him valuable to come in here and talk, he thought he was getting out. That's when those letters were going out. Those letters are going out, and he thinks he's getting out because he's got the lawyer, they got the cooperator from Holly Bobo to walk. And that's the type of thing you have to remember when you're assessing whether you can rely upon Cornelius Smith and anything that he said. The guy that sat in that chair, and he was asked by Mr. Hagerman, when you killed Adolph Thornton, what did you feel? And like it was nothing, said, I didn't feel anything. Let's try to get paid. And that's the guy that they want to put in front of you and say, believe it. You know, he went and talked about exchanging money, right? Getting $800, right? At one point said, do you find people that he got that Mr. Johnson somehow came back into town and he talked on the phone with him and brought $500. And then some other time, some other guy in a Chrysler 300 showed up and provided money to his girlfriend. Well, two things. One, that's not what Mr. Smith originally said to law enforcement. He said that Chrysler 300 came twice, and then Mr. Justin Johnson wasn't anywhere in sight. Well, and what do you know about the Chrysler 300? Jamarcus Johnson, right? Did Jamarcus Johnson say when he was here in front of you, did you ever hear the state ask him, did you deliver the money? As part of you being involved in helping Mr. Johnson, did you deliver money for him? I mean, he asked about the email, or the text rather, about Cornelius emailing Justin's phone and saying, essentially, I need money for the birthday party. That's because Cornelius Smith is lying from start to finish. And then for the first time ever, here in court, he says he wiped the card. Who's in contact? Who's in contact with Govan? According to Mr. Smith. Mr. Smith. Who's not in contact with Govan? Mr. Johnson. Did you hear anything about that? Now, when you go back in the jury room, you're going to be reviewing, obviously, these videos. And one of the things that you have to kind of ask yourself is timing. When you see Mr. Johnson in the elevator with his little girl leaving Crosstown that morning. And of course, there's going to be one exhibit that's the reel where the state had on it 11:51 in the morning. And then, of course, Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time. And put an officer on the stand, the lieutenant, to talk about getting access to the time, how he got the timestamp. But what that shows you is this. They don't know what time it was that day on that video. They don't know. I mean, mistakes get made. I'm not here to suggest that they don't. But you have to ask yourself, okay, the mistake got made, and then there's a timestamp. Okay, we want to put the timestamp one in. That seems like the logical choice. But then you have to listen to the lieutenant, right? And go, Lieutenant, what did you do to check and confirm that these were accurate times? Well, I looked at the live feed when I was in there. I had to have a technician, it's a computer. I don't understand it, but when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say, that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say, it is not uncommon at all to pull surveillance cameras that have inaccurate date and times. Because you have to ask yourself about timing. You have to ask yourself about timing of leaving Crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose, 20 minutes, thereabouts, to pick up Cornelius Smith. They got to leave, then turn around and go to Bradley and go back to the white truck, right? And then get out and be in front of the Makita Cookie at 12:21. Now, that part of common sense and your everyday experiences, what does that tell you about going one place to the other, right? Takes longer, right? If you're stopping places, if you have to park, if you're presumably dropping a child off, there's going to be some kind of a exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time. And I would submit to you that one of the reasons that became an issue is about correcting that time is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. You know, and all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved their Mercedes to the backyard, all of that, according to Cornelius Smith, should have been captured on Hernandez Govan's home security system. Right? He said Govan had a security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down, either the day it happened or the day after, he couldn't quite remember, he texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney, did y'all canvass? Yes, we canvassed the neighborhood. You know, he didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez Govan. Right? We don't necessarily know if they did or didn't, because we didn't get to hear from Mr. Govan. You know, I asked Detective Browning if he was aware of any video from there. No. But if Cornelius Smith, right, is this person that's telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22, when he was meeting with law enforcement. And you know, I'm not saying law enforcement doesn't want to find out who did this. They would have absolutely went and looked. But we don't know. We don't know. And there's a lot that you should know that you don't. Because there's a material witness that should have been called by the state that wasn't called. Hernandez Govan. And maybe some of you sat through this and thought, I want to hear what he has to say. And when I told you in the opening statement, I said, it's important, right, for you to weigh out and be able, as part of your duty as jurors, to be able to compare those two testimonies together. I'm sure some of you were thinking, yeah, that would make sense. I know we talked about that in voir dire, about getting two people to talk to kind of differentiate. You know, some of you that may have been a teacher, talking about that is one of the ways that you try to figure out who's telling the truth, who isn't. But you weren't able to do that. You weren't able to do that. You were deprived of that. And to be clear, as you heard about Hernandez Govan, he was cooperating in this investigation. He met with law enforcement on at least 2 occasions pursuant to a proffer agreement, which meant he was allowed to go in and give information and not have his words used against him later. I don't have the ability to make good on a proffer letter. Only the state does. I don't have the ability to wave a magic wand and give him a reduced sentence if he comes in and testifies for me. So he's to my exclusion. He's to Mr. Johnson's exclusion, and ultimately to your exclusion. And if this is a truth-seeking function, why didn't the state call? And it is. Your job is to find the truth of the matter. And ultimately to go, did they prove their case or not? But you were deprived of that. And the judge instructed you about a jury instruction. And that's the law. That's part of all the different things she told you. This is as important as any of them. And the law states that it creates an inference that the testimony of that witness, Govan, would have been unfavorable to the state. Now, it's up to you to decide whether or not he was unavailable, a material witness, and whether or not there should be the inference. But you're allowed to make that inference in here. And unfavorable, I would tell you, unfavorable to the state means favorable to Mr. Johnson. And knowing that, can you really render a verdict of guilty and have your mind rest easy? And not walk away and go, I just don't know if I did the right thing. Knowing that there was information out there that could have been presented to you and wasn't, that would have been favorable to Mr. Johnson, that I couldn't give you. Can you be morally certain in that instance? In order to be convinced beyond a reasonable doubt that Mr. Johnson is the one in that Nikita video, you have to consider everything. You have to consider what you heard. And you have to go, what I heard from Kristen Garner and Cornelius Smith, was that so convincing that I wouldn't hesitate to rely upon it in making those most important decisions in your own life? Will my mind rest easy if I convict this young man based on their word in conjunction with that video and the other videos and what you didn't hear? The answer is no. When you examine your conscience out there, after you've taken the time to deliberate, I think you'll find the answer is no. Two things I want you to remember, and I'm wrapping up. The way the burden of proof works. You've heard the statement, right? They ain't got nothing to prove. You may say that to somebody. I ain't got nothing to prove here. Justin Johnson, he doesn't have anything to prove here. They do. And we've all heard the term benefit of the doubt, right? Everybody likes to give somebody the benefit of the doubt. You are legally prohibited from giving the state the benefit of the doubt. You can't carry their water for them. again, I appreciate this is, as I said, last time I get to speak to you. The state's gonna get one more opportunity to talk to you this morning. They get the last word. That's how the system's set up. But it has been my honor to represent Mr. Johnson in this case. It's been my honor to present this case before you all. And thank you so much.
Thank you, Mr. Marilyn?
We started this with a little Memphis talk. Those cookies are fire. I think that's how we started it. Little more Memphis talk. What y'all even talking about? What y'all even talking about? A missing witness? Fernandez Gomez? A missing witness? Fernandez Gomez? Absent material witness. And the defense wants to say that is Hernandez Gomez? What do we know about Hernandez Gomez? He's a defendant in the case. He is charged with murder and conspiracy to murder. Whether it's from television or whether it's in black and white at the bottom of that same instruction, a defendant has the right not to testify and incriminate himself. He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here, testify. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, is actually what they used to call it, where you didn't have that right not to come in court. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe him? Or look at Cornelius Smith. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's caught. So don't believe him. So I made a mistake on one slide about the time, so it was corrected. So we can't believe the video. You know, there's a word that actually exists because it's a thing. It's corroboration. It's corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? Because that's how we should judge stuff. Did Kirsten Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, we didn't pay for the car. They're riding around with guns in a stolen car, and they're trading it with their buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that? Well, there's the Valero video, which shows something strange. Shows Kirsten come up in the car and somebody else get in and drive off. Strange. Another little piece of corroboration, where's Justin Johnson's phone at the time? Well, in the area of the Valero station. Can you say it's in the parking lot? No, you can't. But it's in the Valero, in the vicinity of the Valero station. But my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Valero video. We just don't have a Haven Court video. We don't just have a crosstown video. We don't just have a defendant who's like, Cornelius Smith, I'm guilty and so is he. That's us two in the parking lot shooting them. We got Justin Johnson's actual phone. We got his actual phone. And this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the Makeda shooting, and as soon as you see the video of Crosstown of him leaving in the exact same outfit, in the white Mercedes, case is over. But we keep going. As soon as you hear from a co-defendant who's like, that's me in the parking lot shooting Dolph, I'm going to prison. And Justin Johnson's the guy next to me doing it. Case is over. As soon as you see the Haven Court video, 40 minutes after the shooting of the two shooters and his cousin, case is over. But then things kept on happening. That if you didn't have all that proof, would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We had his phone. And the night before, we have a text. The night before the homicide, we have a text. From who? Treon Ingram. To who? Justin Johnson. Sending him what? A picture of the white Mercedes. What do we have next? Another text. Justin Johnson. Treon Ingram. Dropping his location. Bradley. Kiss and said they met on Bradley. Then they drove to Valero. And they switched cars. That's corroboration. So do you have to be able to trust Kissinger with the keys to your car? Of course not. You think I trust Kissinger with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because it's on video of Valero. It's documented in his phone with literal pictures and locations. This is plain as day. Do I have to believe that Cornelius Smith is talking because of pangs of conscience? No. No. He's talking because he got caught. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony, like Kissinger's, that we can corroborate? Oh my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I missed a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius Smith from him right before he comes and picks him up at Lamar and Sons. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important. Because here's another little, real tricky truth test. Justin's driving the white Mercedes. You see it in the video, of course. Cornelius testifies to it. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway there on the front. Well, we know the white Expedition is also Justin's car. They're sending it across town for testimony. What do we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment. It used to be called Two Lanes, Gospel Gardens, the address on Haven Court. We see the white Expedition arrive. And who's driving? The white Expedition. Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Cornelius Smith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Cornelius Smith driving and Justin in the passenger seat, just like it had to happen, just like Cornelius Smith told you when he testified. We do the shooting. Justin's driving the white Mercedes. He hands me the keys to the Expedition. We get to Bradley. I jump out. I get in the driver's seat of the Expedition. Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. And what do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see in the video, Haven Court. We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in the Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax come, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the Expedition, and the two pull out. His testimony is corroborated over and over and over. And that's so incredibly important as we do trials. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments when this trial was just over again for the 5th time was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after the shooting, Justin calls and FaceTimes with somebody. He says it's a big joke. The guy that put the money down for this. Number 2 is CMG. Guy that put hits on the other artists too. Cornelius says it's a FaceTime. Spelling out Dolph with your hands. And what do we find in Justin's time? I mean, delete the stuff all day long. He did. Whole day. November 17th. Delete it all day long, but it's still in there. A call and FaceTime interaction with him. Justin Johnson with Big Joke. With Big Joke. Cornelius tells you. And there you see it in black and white. It's not 1981. No, that's true. Call and camera and everything else, but you're also walking around your pocket with a phone that you can delete a call on, but it's still there. The times you called Cornelius Smith that morning, still there. The time when you called and then FaceTime with Big Joke right after the murder of Dolph, still there. The videos from Haven Court that show you arriving, still there. The videos of Haven Court that see you changing clothes. Did he have enough time to do it? He didn't have enough time to do it. He left crossing at 10:51. He had over an hour and a half to go drop off his kid 20 minutes away and drive 10 minutes Total trip probably take you 30 or 40 minutes. Yeah, you have enough time to do it. We saw him do it. Memphis talk, all the times. All the times. Before the murder, we see him at Crosstown in the murder outfit. Similar clothing? No. Identical clothing. Patch on the legs, Bass Pro hat, everything. Before the murder, the Mercedes. Similar Mercedes? No. Back end damage, just like we saw in the video. During the murder, again, caught on video. White Mercedes, back end damage, the exact same clothing across town. Looks like him. Right-handed like him. Gloved up, like Cornelius said. Driving away from the murder. Who you calling? Who you texting? Vigil. Caught before. Caught during. And then caught after. At Haven Court. Video of them arriving and leaving. Caught before, during, and after. That's called being caught all the times. All the times. He is literally caught before, during, and after. Caught all the times. And then what does he do? Then what do we know? Another Memphis phrase. Get on down. Get on down. Cross town the last video. Packing my suitcases to head out of town. Packing my suitcases to head out of town and get on down. Like the police tell us, a manhunt. Not just in Memphis, well beyond Memphis. As Jamarcus tells us, he's going in and out of town. As Jamarcus tells us, he sees pictures on social media, Rolls Royce, stacks of money. Get out of town, get on down. The crime has been committed. Dolph has been killed, and we literally see him at the elevator with his suitcases getting on down. Flight can create an inference of guilt. Well, yeah. This case was over when you saw the videos. This case was over when you heard from the co-defendant. This case was over when you saw him at Crosstown with the suitcases leaving, knowing that the manhunt was coming and he was out of town and leaving. Really. Really. Now it's time for us, though. Now it's time for us to get on down, but we don't get on down by fleeing. We don't get on down by hiding. We don't get on down with pictures of Rolls Royces, stacks of money. We get on down by doing what's right and doing our jobs and looking at the evidence, the witnesses, the corroboration, and applying the law to those things. We get on down by doing justice. We get on down by saying you are called all the times. You are called all the times and you're guilty of all the things. Conspiracy to commit murder? I just heard, okay, let's at least cut him a break on the conspiracy to commit murder because man, he wasn't there for at least like one of these meetings with Big Joe or something. That's why I just heard. Let's cut a little break on the conspiracy of murder, because he's not at this meeting with, Big Jug and Govan and Cornelius. So let's cut a little break on that. That's what I heard. Let's cut a little break on that. There's no requirement in the law that every conspirator have to be at every single meeting with each other. There has to be an agreement, an understanding. And there was clearly an understanding. Big Jug is going to pay money to take out PRE artists, and at the top of that chain is Dolph. Now, does he demonstrate any understanding of that? Is there anything he does that shows he's part of this, like, understanding that this is going to happen? Yeah. He literally shows up with gloves and guns, has a white Mercedes he gets from Treon, has Cornelius driving next to him, and they drive and go do it. So the idea that, okay, he committed the murder, we give him a break, no. He's guilty of the conspiracy, just like they're all guilty of the conspiracy. And of course he's guilty of the murder because we watched it on video. Short thing. Just one lyric. Just one lyric. You too real. Dolph, you too real. He rapped about what he calls come up. What he saw in their friends, what he saw in his family, growing up. Too real. He rapped about people that he had a rivalry with. Too real. Dolph, too real. Included disses of dangerous people like Big Chuck. You're too real. Too real. Too real. Last moments of his life, last seconds of his life. How long was the videotape? 30 seconds? You're too real. Dies on the floor of a neighborhood cookie store in Orange Mound. It's real. You're too real. Your family misses you. Erica and Mia, the kids. You too real. This is real. This is too real. And when the killer, one of the two, is caught on video, all times, we even watch him get on down. It's time for us to be real. No, we don't need Memphis talk for that. It's called just do what's right. It's as simple as that. Just do what's right. Cornelius Smith and Justin Johnson killed Adolph Gordon Jr. November 17th. We watched it happen. Cornelius Smith, Justin Johnson, Hernandez Govan, Big Jug, they all conspired to have it done, and it was done. November 17th, 2021. And as he did, he was already a convicted felon. He should be found guilty of all counts. We do what's right. That's how we do. Guilty conspiracy to commit murder, murder in the first degree, and convicted felon in possession of a handgun.
All right, ladies and gentlemen, I got a few more pages of the charge to read to you. I'm gonna pick up on page 29. Verdicts. Count 1. The charged offense in the first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least are facilitation to wit, conspiracy to commit first-degree murder. When you retire to consider your verdict in the first count of the indictment, you will first inquire whether the defendant is guilty of conspiracy to commit first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. If you unanimously found the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit, conspiracy to commit first-degree murder as charged and included in count 1. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit, conspiracy to commit first-degree murder as charged and included in count 1 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offense as charged and included in the first count of the indictment under the law defined and explained to you, it is your duty to acquit him. Your verdict will be: we, the jury, found the defendant not guilty as to count 1. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 2. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. You will next inquire whether the defendant is guilty of first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of first-degree murder as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, second-degree murder, as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of second-degree murder as charged and included in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, facilitation to wit, first-degree murder, as charged and included in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit, first-degree murder, as charged in count 2 of the indictment. If you unanimously found the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least, as set forth on the previous page. If you find the defendant guilty of a lesser included offense, your verdict will be: We, the jury, find the defendant guilty of, as included in count 2 of the indictment. Insert the lesser offense in the blank. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the second count of the indictment under the law defined and explained to you, it is your duty to acquit him and your verdict will be. We, the jury, find the defendant not guilty as to count 2. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 3. The charged offense in the third count of the indictment is convicted felon in possession of a firearm. There are no lesser included offenses. You will next inquire whether the defendant is guilty of convicted felon in possession of a firearm as charged in the third count of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the third count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdicts will be: we, the jury, find the defendant not guilty as to count 3. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict on a particular count, the foreperson will write your verdict as to each count on the outside of the jacket and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictate and justice demand. All right, as I told you before, this is the official copy. Please refer to it. There's just been a couple of minor changes made, but nothing substantial, nothing substantive. Let's put it that way. A few typos I ran into, but other than that, please use yours, make notes on yours, refer to yours. But this is the official copy if there's any discrepancy. The jacket, please. You will have all of the exhibits. We'll go back with you. Please look them over. If at some point you want to watch videos, please let us know. Do you have did you make the list? Okay, is it?
It's been numbered as an exhibit, Your Honor.
Okay, so it's with the exhibits. Do you have a clean laptop? So they can you get us a clean laptop so they can watch videos as they want to watch?
They'll get it, Your Honor.
Thank you. So you will be provided a laptop that's clean, so you can watch videos how you want to watch videos. And there will be a list accompanying the video to show you, to tell you, describe to you which video is which. That makes sense? Okay. So, is everybody in good shape to deliberate? You getting ready to choose alternates? Everybody good to deliberate? I'm going to call three numbers. Once all three are called, the deputy will escort you back to the back to get your belongings. And then the three of you could come back out here, because I have a few remarks for you. And then the rest of the jurors, the 12 of you that will be seated to deliberate, will go back and begin your deliberations. Okay? Juror number 18. Juror number 13. And juror number 12. You guys can look at these if you'd like. You can review these. If you'd like.
Yes, sir.
I said. Oh, no. Just always. Music. Just make it a point to show you.
Yes, Your Honor. Thank you.
Lunch should be here in a little while. Let me admonish you now. All 12 of you will deliberate at the same time. There should never be an opportunity for 2 or 3 over here eating and the rest of you are deliberating. If you decide you're going to eat, everybody eat. If you decide you're going to take a break, everybody take a break. When it's time to deliberate, everybody deliberate. Just let the deputy know that you're doing something different besides deliberating. Okay? Jurors, you are excused.
recess.
Court stands in recess.
What's up? What's up? What's up? Hey guys. I tried to come in and soft that time because people say every time I start talking, I know I scare them. So we're on verdict watch. What do y'all think is gonna happen? I'm about to start a poll. I don't think this is gonna be like a situation where you know how sometimes you have trials and like we gonna have this gonna be wrapped up by 5 p.m. And if it ain't, it's not wrapped up by 5 p.m. It certainly should be. I mean, I don't know what they would need to talk about. Have y'all heard of the YouTuber just say no to Skull? He's been one of the YouTubers that's been covering Dolph trials very hard from the beginning. He's actually had the girl from the cookie shop. Well, he actually has Raven, the girl from the cookie shop, on his page, on his show often, several times. She was actually up there the one of the trial because if you don't know, in the beginning, a lot of people blamed the cookie shop because there was a lot of there's a lot of iffy stuff going on with their statements. One person said this, one person said that. Like it was a bunch of iffy stuff going on. So a lot of people assumed the cookie shop was involved in some way. It's documented that when this was supposed to be planned, it was in Miami 6 months before it happened, and Raven, the Makita's girl, was there. Like she hangs out with people from CMG. Everybody brought up her Facebook where she's in pictures with Juke and folks like that. So a lot of people had blamed the cookie shop for a long time for possibly setting him up, because the week before this happened, he infamously made that IG post about, oh, Makita's cookies, they're the best in the world. Every time I come here, I'm going to Makita's. And then the very next week, he goes to Makita's. Yeah, so it did seem kind of strange, but I guess they have cleared them. I'm a little still skeptical of myself, honestly. Yeah, he's done. This boy is done. This is, and I don't know. I mean, why would you play with your life? Why would you gamble your life like that? This man knew everything that the state had against him because he got it in his discovery packet. No matter what time or what time frame, Justin still knew that because the state had to tell his lawyer, and the lawyer had told him. So all this evidence that they presented to us that we looking at like shit, he don't stand a chance. He had this. So it's like I understand rolling the dice. I got a friend, well, he's in prison, but I got a friend and I was talking to him about that. I was like, why do some criminals or whatever, they see all the evidence that the state has and they still roll the dice. They still take it to trial? Because the thing is, them folks get mad when them folks get mad when they have all this evidence that you make them do their work, basically. Them folks be mad when you make them do their job. So if you make them go to court to prove that you did what they know they already, you know what I'm saying, what they have evidence to prove that you did, like most of the time you're likely to get a harsher sentence than if you were to plead out. So I understand some people don't want to plead out and why, but it's kind of like you gotta roll the dice. Now in some cases you don't get less time. Whether you could plead and still get the same amount of time as if you went to trial. It just depends on the circumstances. But and then there are the times where it seems as if the evidence is so great, and I mean, we don't know what that jury back there talking about. The jury could come back and be like, nope, we weren't convinced. It happens. But in this case, I probably would, especially being as though he wasn't even the one that was in contact with Govan and them, especially when he wasn't even the one that hopped out the car first and fired all those initial shots. Man, he should have been the very first one talking to the police. He could have gotten his charges reduced a long time ago with some, with negotiations and stuff like that. He could have got his charges reduced a long time ago because he had less culpability. They can't tie him to Govan like they can Cornelius. They can tie Justin to Cornelius and then tie Cornelius to the rest of them. I think rolling the dice. Like I said, we don't know what that jury back there doing. I kind of think rolling the dice on this is not very smart in this case. There's the off chance that his lawyer created. So we will see. But I don't see this lasting past 5 o'clock. Them folks ready to go home. They're not trying to come back and be dealing with this tomorrow on a Friday. Nah, their boss probably done already given them the whole week off. So they're going to go ahead, deliberate, get this verdict wrapped up today, and they're going to spend tomorrow chilling. I'm trying to pull up another video for y'all to watch. 1 second. Not smart at all. You're right, Kavir. Like the evidence was solid. Like the apartment with the same clothes. Really, they should have changed clothes in the car. They should have had a change of clothes in the car. But like the prosecutor said, these weren't professional hitmen. These was little ninjas. They sent little ninjas to do a big boy job. And like I said, I get the whole, this was spur of the moment. They just happened upon Dolph or whatever. But that day they set out to harm a PRE member because they knew the turkey drive was that day. So either way, they should have been prepared. And if they should have had changing clothes in the car. Look, just like the man said, it's not 1981 anymore. Like if I hear that one more time. But it's not 1981 anymore. You are on camera from the time you leave your house. In this day and age, you are on camera from the time you leave your house. They got cameras in the stoplights. They got cameras in the on the poles. Like you're on camera. Tesla's got cameras. So hell, you on camera in traffic. Like, I'm just saying, like, when you doing a job of this magnitude, you gotta know what you're doing. Nah. And the sad thing about it is nobody won. Nobody wins in this case. Because at the end of the day, this is 3 black men that have lost their lives. Well, it's probably gonna be two more. But for right now, this is 3 black men that have lost their lives and have left children behind with no father. Dolph had kids. Justin Johnson had kids. I think Cornelius got kids. Like, and the cycle continues. The cycle continues because of all 3 of these black men that are now lives are forever changed. It's inevitable, just based off history and how things go. One of their children, they financially set, so hopefully they won't have to run to the street life. But between Justin's kids and Cornelius' kids, they finna grow up with their father in prison for killing one of the biggest rappers to come out of their city. I'd move. I hope they don't got it. I'd move. I wouldn't tell nobody my daddy is Justin Johnson. I wouldn't tell nobody my daddy is Cornelius Smith. I wouldn't tell a single soul I'm related to Hernandez Govan. All of this for what? And I was watching another YouTuber last night, and he made a good stuff included. Like, okay, see, everybody's talking about a CMG Rico. Now, whether there's gonna be a CMG Rico or not, nobody knows. But I do know whatever's gonna happen, it is not gonna be quick. It's not gonna be nothing that's gonna happen in an instant, because look at the YSL trial. In this Rico, they talking about cases that people have already done time for, crimes that have already been adjudicated, already ran out on, because it's a RICO. Mastermind, and that it was set up by Jill. Like, all of that has to be proven first before they can touch CMG, because they can't. It has to be, you know what I'm saying? If they find Hernandez Govan guilty, and we don't know what's gonna come out during his trial, because apparently he was like working as an informant. It was always weird that he was out of jail. This is the guy who y'all claim to be the mastermind, and he got bail. That was always weird, or whatever. But if anything is gonna happen to CMG as a record label or as a whole, it's gonna be way later down the line, after all this stuff has been wrapped up. Like I said with YSL, and a lot of those cases, like what's his name, Zachary, that was on the stand yesterday. They kept talking about the case that he pleaded guilty to, the game case, and Miss Love kept asking, "What was that game, YSL?" And he was just trying to say, "Oh, I pled guilty because I was trying, blah 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 blah." But they had to prove, they had one or more cases already where people had admitted to gang charges dealing with YSL, and then they brought this RICO charge. So now, regardless of whether these boys admit YSL is a gang or not, they still have other cases that have been adjudicated where people have admitted YSL was a gang. Now, whether they did it to get out of jail or not, whether they did it to get a reduced sentence, clearly you can tell DA Love and Willis, they don't care about that. But they had to get that stuff out the way first, because now they can wrap it up into a big old box and say, hey, Rico, look at all these other crimes that we tried and convicted and they admitted to. What you do get in town. I'm saying, like, I don't know, I can't say we all, but especially speaking for females, we all watch true crime shows, Dateline, 48 Hours, Snap, all that shit. At this point, if you are conspiring to commit a crime with somebody, it's a lot of things you shouldn't do. One of them being at the very top is you should not call that person that you are conspiring with the crime with right after the crime. Because if they have connected you to this crime in any way possible, any way, shape, or form, the very first thing they're going to do is get your cell phone records. That's like in 2024, getting cell phone records is like getting a stapler. It is standard. It is mandatory. It is mandatory. If we have any thought that you have involvement in any crime, the very first thing we're going to do is your cell phone and DNA, fingerprints, all of that. But once they get your cell phone, that's why people say your cell phone is the feds. I mean, it really kind of is. Your cell phone stores so much information that people aren't aware of. And there's so many people out there that think, oh, I'm going to just delete my call log. What is that going to do? Deleting your call log, just delete your call log. That's about it. But whoever your carrier is, they have that information stored in a database. And all it takes is a piece of paper for the police to get it. So besides the 6K high def Dolby digital video that they got, these boys, the person that you are accused of conspiring this crime with, you call them after the crime was committed a couple times. Why would you be doing that if you weren't there? If you didn't have anything to do with this, why would you be doing that? If you didn't have anything to do with this, why were you in the stolen car that did this at the time that the crime happened? Going back to YSL, that stolen car. Not now, one person in that courtroom can put Thug in that car. But they got a couple of people and some video that put Justin Johnson in this stolen car. It's just like I said, as a defense attorney, I guess he did what he could. I mean, you gotta have some kind of defense. You gotta try to do something. He tried. He did what he was supposed to do. He said, with cameras everywhere, I would have slept in my mask the night before or something, because look who your target is. You feel me? Look who your target is. You try, like, okay, yeah, they said they wanted any member of PRE, but you obviously wanted the big fish. They didn't come prepared to get the big fish. They wasn't acting like they was trying to get the big fish. Like, they wouldn't act like they was trying to get anybody. Like I said, they should have had change of clothes in the car. Y'all on video following the man. And let's just talk about stolen cars. If you gonna steal a car, if you gonna get a hot car to go do a crime, is a white Mercedes really the kind of car you wanna go commit a crime in? A white Mercedes that you driving around the city and people seeing you driving and motherfuckers know you don't have no money to get that kind of car. So everybody know it's stolen out the gate. And I remember when they was talking about that, they stole that car from this little Caucasian girl at the gas station. They put a gun in her head and they stole that car from that little Caucasian girl, and she was terrified. And then they used it to commit murder in. So of course, when they found the car and it traced back to the little white girl, to the little Caucasian girl, you know, she was like, wait a minute, like I don't have anything to do with this. But imagine your car getting stolen and then you find out 2 weeks later that whoever stole it has taken somebody out and committed, I think it was like 2 other shootings in that car. Crazy. Right, you're right. Amateurs. They didn't think nothing through. You should have thought through what happens if I get shot. Because you got to know that Dolph got it on him, and he got somebody with him that got him on him. Everybody knows Dolph got bulletproof cars. So they had the wherewithal to know, okay, let's catch him out of the car. But you didn't have a plan for what if he got somebody with him and we get shot back? No. I know, Danny. I just be trying to keep it cute for YouTube. That's why I say I'm gonna get more involved on maybe some of these other live streams where I can talk the way I want to talk. I just be trying to keep it cute for YouTube. Yeah, man, but I saw the judge pop up a minute ago. It's kind of like you don't really want to go nowhere because you know that you kind of know this ain't gonna last too long. They're gonna be back in a minute. Lunch. When she was like, lunch should be here. Lunch. You might know we don't need lunch. Guilty. I want to go to fuck home. Like lunch. I mean, I'll take the free. Yeah. Okay. Let me stay. Let's pretend to deliberate for an hour so we can get their free lunch. And then let's go home. Y'all remember that episode of it came on the other day. Y'all remember that episode of Martin? And Martin and Cole had jury duty. And Martin was trying to get to Gina because Gina was ovulating, but Cole kept stalling because he wanted all the free food. If y'all don't remember that, y'all way too young for me. Yeah, and Pam was in the trees. Yeah. Cole was like, we ain't ready because I know I ordered chicken fingers and I don't see no chicken fingers. I was like, yo. That was hilarious. And then I think the way it ended was that they had been in there so long that the man ended up confessing, like, fuck it, they taking too long. They taking too long to decide my fate. I'll decide my own fate. I did it. Shit. That's what you wanted to hear.
Explain something to you, man. We voted 47 times, man. Everybody's voted guilty except you, Cole. What's the problem?
This just don't add up. Hold on.
What don't add up, Cole?
I
could have sworn I ordered some chicken fingers. Some chicken fingers. Let me speak to you for a minute. Oh, you arguing about chicken fingers, and we're trying to get out of here, man. The man is guilty of breaking and entering. All right, you're gonna have to vote guilty, man, else I'm gonna have to break and enter your skull. Let's vote again. Come on. Good. So I can get home to my ovulating wife. Okay. All right, does that make sense? That makes sense. Okay. All right, now everybody, please, your ballots in, please. I know what my vote is. Woo! Thank you. We've been here over 8 hours. You know what that means, don't you? Overtime, baby. Give me some. Give me some. You. It's about you. Guilty. That's right. Guilty. That's right. That's right. Guilty. Innocent. Who the hell voted innocent? Hey, don't look at me, man.
I did. Yeah, Cole's right. We did order some chicken fingers, and I ain't leaving until I get me some. I won't let ball on the
Your ignorance is contagious. I'm out of here, man.
Yeah, that was hilarious. I just thought about it because it came on the other day, and I just so happened to stumble upon it. I forgot all about that episode. Cavell, I'm quick with it. Because then he was trying to sneak out the window, and then the judge came in while he was hanging out the window. Contagious ignorance. Hey man, it's sometimes Cole made the show. Sorry. It's sometimes Cole made that show. Yeah, and Judge looked at him like, excuse me, sir. I see like a lot of recaps about Dolph, but it's not like a lot of people going live. It's some people right now in YouTube land and on the internet that are just, they don't know what to do with themselves because YSL is not on today. Like they are just, the world just stops because YSL don't have trial today. That's you know. But what's up though? Oh, for real, Danny? I mean, I'd want to see it. I've always been like, I ain't never been one of his haters though. Like he really kind of always been friendly to me. But you could tell he's grounded. You know what I'm saying? There's the ones that get the money and lose their morals and they grounding. And you could tell Cat went on. He went down for y'all stuff. Dave Chappelle is another one. Like if you anywhere around my age and you remember when Dave Chappelle's show came on, like Dave Chappelle's show was it. Like it was nothing funnier on TV. And then when it was like all of a sudden canceled, it was like, wait a minute. And so come to find out, they basically wanted Dave to sell his soul, like, and they offered him a bunch of money to do it, and Dave was like, nah, like I don't care how much money you offering, no. And sometimes you got to do that. That's what Cat Williams said. Diddy's gonna want a party, you gotta tell him no. So while we speaking on why I did just mention Diddy for a second, the latest news, the latest news, I was actually in the middle of making a video about it before I got on here, but so the mayor of New York has been indicted. He has been under federal investigation for the last couple months. Everybody kind of saw it coming because his mansion was raided. His aides, a lot of people close to him, houses and offices and all that stuff was raided, and that's been like over the last couple months. And then a couple weeks ago, the NYPD commissioner just all of a sudden resigned. That was very weird. And if y'all don't know, the mayor controls the police. Mayor Adams used to be a police. He used to be an NYPD cop. But he has been shady ever since he got in office. And it's really something, and before I even found out how shady he was, it was just something about him that looked very, very slimy. But he is the one that, all of a sudden, for no reason at all, last year gave Diddy a key to New York City. Turns out, of course, him and Diddy are very good friends. Turns out the mayor might be at some of these Diddy parties. But what they indicted him on was, it has to do with money like misuse of funds and stuff like that. Same things most politicians get in trouble for. The big deal about it is he is a sitting mayor and he's indicted, and that has not happened. And he refuses to resign. So there's that. He said he was going to fight the federal government. He refuses to resign. So we'll see how that works out for him. I saw the judge take the stand. They've been playing with my emotions all week. Every time I get ready to talk, like either the camera move or it'll look like they're coming back, and then they don't. But I'm glad Dolph's family is finally getting justice. It's just, man, I would have loved to see Big Jick in court, man. I just really would like, and maybe it'll come out with Hernandez Govan situation, but I really would just like to know why they did not arrest him before he was taken out. Because he was just, he ain't even been going a whole year yet. So, in this case, been going on for 3. Y'all had information on him prior to when he got taken out. So I'm just curious on why wasn't he arrested? I think Govan is going to try. They haven't said whether he's taking a plea. Right now, it's kind of like they leaving it open, like as if he's having a separate trial. He's going to trial just separate from, them, the shooters. But I don't know if he may take a plea after this. It's just really weird that he got bond. You supposed to be the mastermind, and you got bond. So from what I heard on with them talking on the news the other day, I believe they let him out on bond because he made a deal to get information or bring them back information. And I believe that's what he's been doing, or part of his duties while he's been out. I know he's supposed to have been on strict house arrest, but there's also at least 3 news clips of where the judge had to bring him into court because he was not abiding by his house arrest. I mean, he has an ankle bracelet, but he was out of town. He was doing all kind of stuff. Like, and so she was like, well, do you want me to lock you up? Like, but he's not safe in jail. He ain't safe out of jail. And that's what the judge told him, that you're not safe in or out of jail. Your life is in danger and you are not abiding by your release conditions. And so they had to reel him in a couple times. And like I said, for those who don't know, this is not the original judge that was on the case. There was a guy that was on the case, but he was asked to be recused. And so now we got Auntie here. But the judge definitely told Govan that you're not safe here or in jail. So you need to start doing what I told you to do. And he was right. Because I'm pretty sure if Jook could have got the Govan to shut him up, he would have. But Govan was being monitored. He was working with them. So it wasn't as easy to get to Govan once he got let out. But I'm positive that if Jook could have got to Govan so he wouldn't implicate him, he definitely would. And it probably would have looked like an accident. And he lost, excuse me, he lost a daughter behind this. Lotta Cash Desto is Govan's daughter. So after you lose a daughter behind this, it changes your mind. And she didn't have nothing to do with it, except for the fact that she helped Straight Drop hide out for a little bit.
Lotto
Girl.
Cash Desto is on her way up in the industry and linking with superstars like Lil Uzi Vert, and that's why fans were shocked after she was brutally murdered in 2022. At first, it seemed like a random hit, but today we're breaking down the crazy story behind why she could have been killed. On September 24th, 2022, Lotto Cash Desto was leaving the club with her friend in Houston just before 3 in the morning. Desto and her homegirl, Amara Hughes, had just left someone's birthday party at a club called Spire and were on their way to another club in the city. While they were driving down Richmond Avenue, another whip stopped in front of them. They sat there for a second, then 2 dudes wearing bandanas on their faces got out of the car with guns and started walking towards Desto and Amara. Desto was ready for the smoke though. She had her own gun and started letting off shots out of the whip. She caught one of the dudes in the stomach, but they busted back and ended up killing her with a shot to the head. Her friend Amara got hit too, but luckily she was able to make it out alive. When the police rode up to the scene after the shooting went down, they found Lotto Cash Desto dead in the driver's seat and Amara next to her bleeding out from a bunch of gunshot wounds. And in front of the whip, they spotted a bunch of shell casings from a rifle and pistol. It's not clear exactly how it all went down, but one of the shooters left his homie bleeding out on the scene. The cops found a dude named Christian Isaiah Williams in a parking lot across the street from where Desto was killed. He had a gunshot in his stomach and was rushed to the hospital. But after Amara told the cops what went down, they realized that Christian Williams was one of the shooters and booked him for Desto's murder. Williams was charged while he was still recovering in the hospital, so he didn't have a chance to do the race. And when the cops started pressing him about what happened, Williams couldn't keep the story straight and kept changing it up. Then in April 2023, the cops arrested another dude named Jeremiah Smith for the shooting. It's not clear how they found out he was involved, but they tracked him down while he was hiding out in Alexandria, Louisiana, and brought him back to Texas. When the news broke about Desto getting killed, it shocked the whole rap game. Before she died, Desto had to move away from her hometown and was living in Houston. Most rappers who get murdered die in their hometown, and that's what made the situation to her and left her dead in the street. Desto had been making music her whole life, but right before she died, everything was really about to pop off for her. She had just linked up with Lil Uzi Vert and signed a deal with his label. They dropped tracks together like Lunch Desto. He even paid for a funeral and gave a speech. During the funeral, he told everyone that he had to go to rehab for a while and that Desto would call him every single day to make sure he was good. They didn't know each other for long, but it's clear that Uzi and Desto were seriously tight. And on the track, Days Come and Go, admitted he dropped 200K on the funeral when he rapped, "I got too much on my mind, I got too much on my plate. I spent 200,000 on Desto funeral. That's in the state. I don't know why they be mad at me, cause I'm expressing my ways. I don't know why I cry sometimes. Maybe I'm blessed with no faith." Lil Uzi wasn't the only star in the rap game who was missing Desto. After the news broke about her death, Kodak Black hopped on Instagram and said he was about to sign her too. Yak planned on buying Desto a new Corvette and giving her a bunch of cash after he found her on Instagram and started rocking with her music. Desto was linking up with rappers all over the country and even hopped in the booth with a rapper from Jacksonville, Florida named Fulio. Fulio is one of the hottest rappers in the city, but we gonna break down why some people think working with Fulio got Desto killed. After Chief Keef, Lil Durk, and all the other Chicago rappers put drill on the map back in the early 2010s, other cities started their own drill waves, and Jacksonville's is probably the craziest. There's been a war going on in Jacksonville for years, and Fulio is one of the main dudes in it. He made headlines for dissing his op, Young and Ace, after Ace lost his brother and two homies to a drive-by. But one of Fulio's biggest ops was a dude named Leaky. Leaky allegedly shot Fulio's girl when she was driving Fulio's whip back in 2020. She survived the shooting, but ended up losing a finger. And on the track, I Don't Smoke Kendra, Leaky, I'm a Leaky. Cool. That whole thing tweeted. Leaky also weed. A lot of people say Leaky was shooters in Jacksonville, but in September 2020, it all caught up to him, and Leaky was killed in a drive-by. Fulio's been dissing Leaky like crazy ever since he died. On the track, All Gas, he raps, "Shot my car up twice, then hit my bitch. Now Leaky rest in peace." And on the track, Leaky, he said, 100K, he'll shake the room, sweep his block.
Studio, and she just in that bitch is cheating. I'm like, what the fuck? She keeps smiling for us. She like, man, I'm a big fan of you. I ain't gonna count. I'm from Memphis. They fucked up about your shit, this and that.
And that's when they made the track pop out together. Linking up with Fulio was good for Desto's career, but some people think her verse on the track might have gotten her killed. On the song, Desto raps, "I'm with Fulio, Slot, and G, and he got me smoking on Leaky." Desto wasn't involved with the streets of Jacksonville at all, but she dissed Leaky, who had a lot of homies in the trenches. After Desto recorded her verse, Fulio tried to warn her about what she just said, but Desto was still cool with dropping the song.
So we do the song and shit, and she said one bar on that bit, and I told her too, I say, you know what you just said, right? Like, you just said, right? And even the people I'm forward, they were like, man, why she did that? Like, she ain't even from Jacksonville. Like, I'm like, shit, that's her. Like, you know what I'm saying? I can't tell nobody what to do, but I tried to stop it.
When Lotto Cash Desto ended up getting killed in Houston, a lot of Fulio's ops hopped on social media and started dissing her. Leaky's homie J. Breezy said, "Now you dead. Wasn't even in your hometown. Should have acted like the gender you are, but you wanted to act like a nigga. Now look at you, fitted casket." Some fans thought the dudes in Jacksonville might be involved and killed Desto for dissing Leaky, but there's nothing actually tying them to her death. J. Breezy even admitted on No Jumper that he could have been the bigger person and never dissed Desto, but he didn't understand why fans were so pressed about him dissing her since Desto dissed his dead homie first.
I could have been a bigger person than I said. Though. I don't know why everybody mad. Like, there's no point in being mad. If y'all ain't give a fuck when she hopped on the song saying she was smoking my partner, y'all supported that shit.
Desto's murder probably didn't have anything to do with the Fulio situation, but there's a different theory about her death that's related to the shooting of another Memphis rapper and legend. Back in 2021, young Dolph was brutally murdered in his hometown of Memphis while he was picking up cookies from his favorite bakery in the city. Before he died, Dolph had been beefing with Yo Gotti and the CMG label for years, and the situation had already led to a couple of shootings. So when Dolph died, rumors were flying from the jump that Yo Gotti and his crew were behind the hit. But when the cops started making arrests, the whole case got a lot more complicated. In 2022, they booked the alleged shooters and a dude who helped them get away. But at the time, nobody knew why they wanted to kill Dolph and crashed out in broad daylight like that. Then a few months later, the news broke that the police booked Lotto Cash Desto's dad, Hernandez Govan, for plotting the whole thing. Hernandez Govan was a major player in the streets of Memphis and had ties to a lot of people, including Yo Gotti and his brother Big Ju. When Desto was killed, Govan hadn't been arrested yet, and he hopped on Facebook and said, "I think I cursed you, Destiny, with my lifestyle. I apologize, baby." Then just a couple months later, Govan was officially arrested for planning the hit on young Dolph. Rumors say that Dolph's homies knew Govan was involved before anyone else, and they took out Desto to get revenge. Plus, before she left Memphis, Desto linked up in the studio with a rapper named J Money. J Money was part of a crew called Trula Mafia and had a big name in the streets. Young Dolph was also cool with J Money back in the day and had ties to Trula Mafia through him. But that all changed when J Money was murdered in 2016. His death split the crew up, and some Trula Mafia members went their own way and started a set called Double R. Young Dolph fell out with Trula Mafia, and rumors say they were involved with his death. So after Trula allegedly killed him, Double R allegedly got active and started sliding on anyone affiliated with Trula, including Lotto Cash Desto. A rapper named Bandman Kevo knew Desto and said that the dudes who killed her might have wanted to get at her dad Govan instead. But since they couldn't catch him, they decided to kill her. Bandman Kevo said that Desto was a real hustler and definitely on her way up in the industry. But some people claim Desto might have been killed over some other situations she had in the streets. According to reports, Desto had some arrests back in the day for assault.
Yeah, so Shorty was living like her own little gangster life outside of whatever her daddy was doing, obviously. But the people that they arrested for killing her have not been traced back to Memphis as of yet, or that they have released. So maybe it has something to do with it, maybe it didn't. It's just real coincidental. But like I said, so Govan has lost a daughter behind this, so I could see him definitely jumping ship and cooperating and telling them folks what they want to know about Ju. We just don't know what he's told them yet. Like, he's in the courtroom now. The judge ordered him to be in the court, to be present for straight drops proceedings, even though he's not on trial. I'm real curious to see what happens with his case, because even though Juke is gone, they might say, okay, we can't get Juke, we got you. You was involved with the planning. You exchanged money. Thank you for helping us out. Thank you for working for us, and thank you for telling. But since we can't get Juke, we gonna get you. Or they gonna get CMG. But like I said the other day, anybody that was ever questioned, anybody that was ever thought to be involved in Dolph's death is deceased or locked up. There was a dude named CEO TZ, and he was a part of the other gang or whatever. And he was found in his car was it a couple months ago? But they brought him in for questioning for Dolph's death, but they never charged him. But just the simple fact they brought him in for questioning, they got him up out of here.
Tell us Joshua Taylor was named a person of interest in the young Dolph murder case back in February of 2022. Officers say the shooting happened at Spotswood Avenue near Bunton Street. Police received a call about a body found around 1 p.m. this afternoon. A short time later, Police Chief C.J. Davis made the scene. Neighbors telling us they think the victim was actually shot last night. Police are telling us the investigation is still ongoing. We'll keep you posted.
So yeah, anybody that was involved, it has been dealt with. in some way. Well, I thought court was back, but guess not. But yeah, the cycle never ends. You get one of mine, I'm gonna get one of yours. And if I can't get you, I'm gonna get the one closest to you. And that's a cycle we as an African I mean as an African American community, we keep going through it. About well, yeah, Danny, especially if the verdict ain't what people want it to be, but they probably gonna be in the uproar either way. Like it's probably gonna be like it's probably gonna be like a like a Dolph celebration day. The streets of Memphis is probably gonna be crowded, like with just people celebrating. He was a very loved man there. I mean, everywhere, but especially there. If it wasn't for the fact that somebody might die tonight, I probably would love to be there for the celebration. And I hate to say that like that, but it's reality. If you watch Memphis news, it's kind of depressing. It's reality. Yeah, I mean, then you got the people that are mad that they can't get juke. I know that Gotti's sister and his mom have been, I don't know if they've been in protection or if they just been protected by like Gotti's own personal security, but they've been careful. She said, I just want some blues and barbecue. Right. Just want to go have a good time. It's just have that good time in the daytime on Beale Street downtown where everybody's at. Don't you take your ass. Don't you call yourself visiting and take your ass to Orange Mound at nighttime. I mean, in hell, that's kind of really like in any city. It's any city. You got places you don't need to be at certain times or at all. I think I seen a video with somebody talking about Atlanta, and they was like, don't, and they was relating it to the trial, and they was like, don't let these folks get up here on TV and thinking y'all can come down to Atlanta and go to Cleveland Avenue and go sightseeing. You come to Cleveland Avenue, you want to, especially the wrong part of Cleveland Avenue at the wrong time. You either might not leave or you gonna leave without your belongings. I mean, I've been to Cleveland Avenue at night. I wasn't there long. I wasn't there long, and I was with my kid too. Like, I don't even remember who was at. I just know I had went to a gas station and I had turned around in the parking lot of a beauty supply store, something like that. I don't know, but we wasn't there long. Right? They think it's sweet, and I think that's what the dude in the video was trying to say. He was like, "Don't come down here sightseeing because y'all see this shit on TV. Like, it's and guess what? It's dudes down there that are looking for y'all. They know that y'all are watching the YSL trial. They know y'all are curious. Oh my God, what's Cleveland Avenue? Let's go see what Cleveland Avenue is about. And they waiting for y'all to bring y'all happy ass round there." You gotta do your research. Hell, even research ain't gonna save you. Just don't go. If you don't know nobody, just don't go. Right. This girl got, I don't even know if I saved that TikTok, Danny. I'm gonna have to find it. This girl rolled up on Woody. Said that she drove 2 hours to Atlanta. She lived 2 hours from Atlanta to begin with. Then she said that she drove all around Atlanta looking for Woody just to see him. Ma'am, you need professional help that none of us can provide for you. This is not something that we should be bragging about. You need help, baby. You don't know this man. And he looked at her like, for real, like, he dapped her up and gave her a hug and was nice to her, but he kind of looked at her like, you crazy, folks. Right, Mookie, they can go to keep riding and don't get out, because I damn sure didn't get out. I turned around in the parking lot. I didn't even get gas at that gas station. I went somewhere else. Like, it just was, and it won't really nobody hanging out there. It just, I'm smart. I mean, I'm Atlanta almost second home. I know where to go and where not to go. And yeah, he do keep saying, don't just roll up. But see, that don't just roll up on people. That goes for everybody, because it damn sure go for me. Don't roll up on me. Don't do that. Don't sneak up on me. But don't do that. Like, that goes for everybody. I think people this day and age, they forget that everybody got a bubble. Once you enter my bubble, you have invaded my private space. Now, what happens to you from here on out, because you have invaded my bubble, is not my problem. Back up. Give me 50 feet. Then say what you got to say, but you don't roll up on me. Like I said, that goes for anybody, because you don't know what people dealing with nowadays. You don't know what they got on them nowadays, and you roll up on somebody like that. Like, nah, I ain't even the one that want to play the games with you to find out what kind of mood you in. I don't even care that much. Yeah, she a real stalker Mookie, and I believe this was before the trial started back over again. And this was when trial was like on break or whatever. So this was before he like really was all over the internet and shit. Right. Me too. I'm that way about my house. Don't come to my house and you didn't call me first. Like, don't do that. I don't care how long you've been ringing the doorbell and how long you've been knocking on the door. If you did not call me first to tell me that you was coming to my house, I don't give a damn how many cars you see in the driveway. I don't care. You should have called me first, because what if I don't feel like having company? Now I got to either fake entertain you or be rude and tell you that I don't feel like being bothered. Either way, you're going to feel some kind of way, but you shouldn't have came. You should have told me first. I got a friend that's gonna make me this doormat that I'm gonna put right in front of my door that said that it stop. If you did not call, turn around. For real. And I got the little camera joint too. So as soon as you hit that bell and that notification come up on my phone and I see who it is, I will interact with you. I will open the app and say, oh hey girl. Oh, my car in the driveway, I ain't even there. Because why did you pop up here for? Now you mad. That's not my problem. But I live like, I moved a couple years ago, and now I live like outside the like city, like the city limits or whatever. So if you come to my house, you came on purpose. It wasn't an accident. You wasn't just in the neighborhood. You wasn't just driving by. If you come to my house, you came here on purpose. And therefore you should have called first. UPS about to get it, knocking on the door and walking away. What they supposed to do, Danny? Danny, what they supposed to do? You want to talk to the UPS man? I don't want to talk. Just drop my package off at the door. Unless I got to sign for it, I don't want to talk. Drop my package off, buddy. Right, just leave it. Just leave it. You don't need to, like I said, unless it's something I got to sign for or something like that, you don't need to see me to deliver my anything. Like, Now, I know a lot of the, like, food delivery drivers do it because they want, that's what they trying to get their tip. Like, if you didn't leave a tip in the app, your Uber Eats driver, they don't knock on your door and they want you to take the food out of their hand because they want you to give them a tip because you did not leave it in the app. So since you didn't leave my tip in the app, you must have wanted me to talk to you. Oh, right. Yeah, I get that, Danny. Yeah, I get that. Half time I don't even get up no way. Like I said, if I didn't have no heads up that you was coming, you can knock on the door. I still ain't gonna get up. And I tell my kids, don't open it. If I'm not home, don't you open that door for nobody. I don't give a damn who it is. It could be your auntie. It could be I don't care who it is. If I ain't home, don't open the door. I remember it was a long time ago. Like with my oldest son, and then I had got something from Rent Center, and I hadn't paid them. And so when you ain't paid Rent Center, they start coming, and after that they be calling and they start coming to your house. And so of course I had been ducking them. I was gonna pay them when I got it. You'll get it when I get it. Shit, man. I had left and went to the store. I come back. My son standing outside talking to the Rent Center man. I'm saying like, fuck did you open the door for? They would have never known you was in the house. What'd you open the door for? Now they want to talk to me about a payment. Like I said, when I get it, you'll get it. Don't call me. I'll call you. Well, we've been calling you, man. Is this still the best phone number for you? No, I got a new one. What is it? I don't know yet. Hell no, they can't sneak nobody in the house. And I told you, and I got cameras. Look, my son just turned 15. He is in high prime teenager mode. Ain't gonna be no sneaking no little girls in here, and I don't know about it. I know exactly what's in a hot. I know exactly when and what point in high school I might have went left. And so I know all the tricks. And we ain't doing that here. You're gonna have to get over on me just like I had to get over on my parents. Figure it out. But I ain't finna just help you. And that's fine. And you can see and talk to your little friends when y'all gather. But you ain't gonna be sneaking no little girls in this house. My kids 10 years apart, so I'm just about to so my oldest is about to start taking driver's ed and driving and stuff like that. So I'm finna do him like my parents did my sister and how all the old school parents used to do. Oh, you can go. You gotta take your little brother with you. Oh, you want to go somewhere? Cool. You gotta take your little brother with you. I had to go with my sister everywhere. My sister had me in all kind of places I wasn't supposed to be. Going along with her shenanigans. I'm in trouble for some shit I don't even know these folks. But I'm in trouble because she didn't drag me along with her. Right, Danny? So you know how it is. All right, well, I didn't talk enough. I feel like we will keep watching and waiting for a verdict. I'll check back in about 30 more minutes if we make it to 30 more minutes. They really shouldn't be gone this long. I'm assuming they're eating lunch though.
I guess we need her.
You will need her.
So y'all can be thinking about it. It's a question that says, is there a legal definition to the term agreement relating to section 1, page 5? I don't think it's a legal definition. I think they're overthinking it.
Yeah, like it's the
It's a common term,
Yeah.
right?
Common term.
I don't know that I can even say all of that to them. I probably can just say no, or
I think you could say no. The only other thing I can think of is you could direct it back to the part of the jury instruction that says, based on your everyday experiences, you know, that one line, I can't remember where that's at, but I think you know what I'm pointing to.
Is there a legal definition to the term agreement?
agreement.
Court's back in session.
So for the record, the jury had a question. Their question is there a legal definition to the term agreement relating to section 1, page 5? Agreement is in quotation marks. So I don't think there is a legal definition to the term agreement.
So, you know, I remember struck as answering a question before with a jury saying that when a word doesn't have a legal definition, you know, as right here, go with the common, you know, usage. But beyond that, I don't think anybody can comment more than that.
Right. Or I can say, no, there is no legal definition, which leaves them with their common knowledge about the word.
I would just suggest to say common, you know, like you said, there is no legal definition, and when there's not common meaning of the word, but everybody.
Mr. Evans.
I think based on kind of thinking about it for a minute, I think that you can only, I would suggest just saying there's no legal definition. I don't have a problem with saying.
If that's what Mr. Evans is asking for, that's fine.
With saying something to the term of, you know, everyday usage, or what I was referring to is consider all the evidence in light of your own observations and experiences in life. That's not really specific to defining a term, so that may not be helpful to them. But I think either way it's phrased, it would be fine.
All right, and I'm just gonna respond to this in writing. We don't even have to bring them out. Okay. There is not a legal definition for the term agreement. Okay,
Yes, ma'am.
I think the less the better here.
I agree.
Okay. All right. Thank you. Adjourn court.
Let's back in session.
We have a verdict to the members of the public. If you don't think you're going to be able to not show any emotion during the reading of this verdict, I ask you to remove yourself now. There won't be, the court won't tolerate any outbursts of any sort from anyone. You will bring me here.
Ready, Your Honor?
Yes.
The jury's now entering into the courtroom.
Ladies and gentlemen of the jury, have you reached a verdict?
You have your own.
Four person? If you would stand and read your verdict, please.
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. We, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. And we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment.
Thank you. Juror number 1, is that your verdict? Juror number 34, is that your verdict? Yes. Juror number 35, is that your verdict?
Yes.
Juror number 11, is that your verdict? Yes. Juror number 14, is that your verdict?
Yes, ma'am.
Juror number 17, is that your verdict?
Yes, ma'am.
Juror number 27, is that your verdict?
It is, Your Honor.
Juror number 33, is that your verdict?
Yes.
Juror number 25, is that your verdict?
Yes.
Juror number 44, is that your verdict?
Yes.
Juror number 23, is that your verdict?
Yes, ma'am.
Juror number 28, is that your verdict?
Yes, ma'am.
Thank you. Ladies and gentlemen, I want to thank you again for your time and attention to this matter this week. Our system of self-government would not work without your service and sacrifice that you made. Thanks again for your time and attention. You are excused.
Jurors excused.
Mr. Johnson, the jury having found you guilty of conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. As the 13th juror, I affirm this verdict. As to the first-degree murder, I sentence you to life in prison. I will set punishment as to the conspiracy and the convicted felon in possession of a firearm after a sentencing hearing. The date for that hearing will be November 1st?
Yes, Your Honor.
November 1st. There's nothing else to take up?
We will prepare the judgment sheet, pass that forward, Judge.
Thank you. And the pre-sentence report. The order for the pre-sentence report.
Sir, let's get that, get those to you.
Thank you. You may adjourn court.
All rise. This honorable court stands adjourned to Monday morning at 9 a.m.
Mr. Hagerman, have you heard from Mr.
I've
Roy?
been texting with him, and he hasn't given me a date yet. My sense is next week is not good. And then he said he had a jury trial the last week of
Free fuck mistrial. Free fuck mistrial.
Show any emotion during the reading of this verdict, I ask you to remove yourself now. There won't be, the court won't tolerate any outbursts of any sort from anyone. You will bring me here.
Ready, Your Honor?
Yes.
The jury's now entering into the courtroom.
I swear I missed it in the blink of an eye, just like you did.
Ladies and gentlemen of the jury, have you reached a verdict? You have your four-person. If you would stand and read your verdict, please.
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder.
Just that one alone is time.
We, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. And we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of.
Yeah, all charges.
Juror number 1, is that your
No
verdict?
surprise there.
Juror number 34, is that your verdict? Yes. Juror number 35, is that your verdict? Yes. Juror number 11, is that your verdict? Yes. Juror number 14, is that your verdict? Yes. Juror number 17, is that your verdict? Yes. Juror number 27, is that your verdict?
It is, Your Honor.
Juror number 33, is that your verdict? Yes. Juror number 25, is that your verdict?
I agree, Danny. I mean, when she read out the charges, it seemed like they like Cavell said, they had a lot of charges to consider, but she just only read off guilty on 3 charges. It just seemed like it should have took them, way faster than it took them.
Time and attention to this matter this week. Our system of self-government would not work without your service and sacrifice that you made. Thanks again for your time and
You shouldn't have
attention.
rolled them dice,
You are
buddy.
Jury's
This was
excused.
just stupid. Justice for Dolph, though. My cousin got justice. Justice for Dolph, though. Because this was stupid. This was the stupidest crime. And for what? His music is trash. He wasn't gonna get signed and blow up anyway. Like it never.
The jury has been speaks committed first-degree murder, and convicted felon in possession of a firearm. As the 13th juror, I affirm this verdict. As to the first-degree murder, I sentence you to life in prison. I will set punishment as to the conspiracy and the convicted felon. The date for that hearing will be.
Yeah, I'm not sure why it was only sentenced on just one charge and they coming back to do sentencing on another one. But it don't matter. He got all his charges was like life charges, like a conspiracy. Like even if you don't pull the trigger, a conspiracy charge can get you life. So once they read guilty for conspiracy.
Thank you. And the pre-sentence report. The order for the pre-sentence report. Thank you. Give me a turn for.
All rise.
I think he knew that shit. I mean, I think it really was a roll of the dice, just because sometimes you can get that one juror or have the benefit of the doubt. So maybe that's why he rolled the dice. But that just all seemed like, yo, and we the super page I go to his face when Cornelio has commented on but you knew this stuff was in your discovery packet. That's why it's just kind of like, bro, why did you roll the dice? But from what I heard, Justin Johnson was the one that was left to like wipe down the car or whatever. But they found Cornelia's fingerprint on it. I think Justin Johnson knew that. And that's why when he sent him that kite in jail, he was telling him just take, because from what I understand, the kite in jail was telling him to take the charge. Like, and he was hoping that he was going to get signed to CMG and get all this money from Juke. And I guess somehow Cornelius would be okay. I don't know what dream Juke and Govan sold these dudes, but they brought it. Whatever dream that they were selling, these dudes bought it. Hook, line, and sinker. And my boy got gone for $800. That's crazy. But we knew he was going to be guilty. It took all day for them to tell us, but we knew it. And like I said, justice for Dolph. Now I'm really just more interested in Hernandez Govan, what his case outcome. I wonder is he gonna take a plea or is he gonna go through a trial? Also, when they come back for the hearing for his next sentencing, that'll be when Dolph's family probably will get to because you know they have victim impact statements and stuff. So that would be very interesting to watch too. But all right, I thank y'all for trial watching and verdict watching with me today. I appreciate it. And I might come back later on, probably about an hour or two. But appreciate y'all for checking in. Thanks. Y'all have a good night. Please be safe wherever you are. If you're in the path of the hurricane or around the hurricane, near the hurricane, by the hurricanes, if it's getting any rain, because we finna get a bunch of it, just please be safe out there, y'all. Love y'all.